Okay, good afternoon, and welcome to this interview with Sarah Bunker. Sarah is a specialist solicitor specialising in employment law, and we're going to do an interview-style approach today based on questions submitted by ESP clients around the government's job retention scheme. So I've known Sarah for years, and she's helped me in my business, advising me, and she's also advised clients. And I know what's always truly appreciated through Sarah's approach is her very practical and commercial mindset when she's approaching employment law matters. So without much further ado, I'm going to start asking the questions, and we'll see where we go from there. Okay, so Sarah, the first question that's come in is how do we actually furlough, and what's the actual process for furloughing employees, or ourselves in fact?
Okay, just to say thank you for the introduction, Wayne, and for the opportunity to speak to your clients. Just the first things first, obviously it's a little different if you're looking to furlough yourself, but we'll touch on that as we go through the questions and answers. But if you're looking to furlough members of staff, firstly, I think you need to think about whether furlough is the right option. Are you actually suffering a downturn as a result of the coronavirus? And clearly most businesses are, and I don't think that the government is going to be looking too closely into that. But obviously it's worth thinking about. And then I think in terms of the employment law situation, do you have a layoff clause in your employment contracts? If you don't have an employment contract that's signed by the person concerned, then you're not going to have a contractual right to lay off. I'll come on to what happens if you don't have a layoff clause in a minute, but if you do, the process is slightly simpler because you have, as I say, a contractual right to require your member of staff to remain at home whilst there is a shortage of work in your business. If you don't have a written employment contract, or if that written employment contract hasn't been signed and therefore there is no right to lay off staff, you are in effect, by putting them on furlough, breaching their employment contract, because what you're potentially saying to them is that you're going to send them home on 80% of their pay, obviously as defined by the government. Whilst some employees might be quite happy to be furloughed in the current situation, that is still a potential breach of contract. So the essential thing here, where you have nothing in writing, is to get their agreement in writing to be furloughed. I will come on to that again in a bit, because what the government are now saying is that you have to have a record of all employees that you furloughed, and you have to keep those records for 5 years. So an agreement in writing or a letter that the employee signs and returns to you is probably a very sensible way of handling this anyway, irrespective of what's in your contracts.
Is it important to get the employee to actually sign that letter in agreement?
I would always do that as best practice, because if you've taken the time and trouble to explain to them what the furlough means and how it's going to operate, you really want to get their formal agreement to that in writing, even if you already have a layoff clause. It's belt and braces, but it means that they have acknowledged and responded to and read and understood what you've said. Because if they don't, then they've always got the opportunity to come back to you. They can give you a call or email you or whatever. And I just think keeping that paper trail is really important going forward, because I think we have seen some suggestions that HMRC will not be backward in auditing these sort of paper trails and the sort of furlough of staff going forward to prevent any abuse of the system.
Yeah, sure. Yeah. Okay, so I guess employers need to decide who to furlough. Certainly, if you've got several, members of staff, you might not need to furlough all of them. Can you give us some thoughts on what employers should be thinking about when they're identifying employees for furloughing?
Of course, yeah. Again, as Wayne says, it's not always necessary to furlough everyone. You may have some work for employees to do, but not others. Clearly, if they occupy different roles, then that's much clearer. But if you have people in the same role and you only say you've got 3 and you only need 1, you're going to have to carry out some form of selection. Now, I don't imagine it needs to be as robust as, for example, redundancy selection might have to be, because we're talking about very unusual times here. But you do have to be careful in making a selection that it's not based on any form of discriminatory reasons. So the sort of protected characteristics, the discriminatory reasons, it's always a difficult one to say, are reasons related to someone's age, perhaps an underlying health condition which could amount to a disability, their gender, their ethnic background, or something of that nature. So you just have to be quite careful about the reasons for selection. So if you fall foul of that, then you could end up having a discrimination claim. And I know that there's lots of commentary at the moment about this whole situation, because the furlough leave has been put in place so quickly to obviously meet the sort of circumstances we're in. There's going to be there are all sorts of gaps and loopholes that are going to be litigated. So don't be the person or the employer that gets a tribunal claim coming through your door.
Yeah, I mean that's really one of the key reasons I wanted to sort of do this interview with you today. Really was, the whole thing has been thrown in very quickly by the government, and employers have reacted very quickly to it because they need to. But in all of this, we won't see the consequences potentially for years. So, I think my mindset is very much, it's not just about the money you can claim in now, but it's also about the potential, not forgetting the employment law aspects of this.
Most definitely.
Yeah. Okay. So I was talking to a client yesterday, and he who works in the they were in the sort of construction industry loosely, or their clients are in the construction industry, and he was talking about employees in the construction industry, not in his business, but of other businesses who were kind of receiving emails to tell them they've been furloughed. And I thought, well, that doesn't sound like very good practice to me. What could you say about maybe the way that we should communicate with our employees when we're furloughing?
Well, we've just talked about discriminating and things. I think in order to protect yourself, rather than sending an email, blanket email, if you can have a conversation. I know conversations that get increasingly difficult. I mean, we're having a conversation now remotely, and I find that quite odd. But if you're going to have a conversation, try and have a conversation over the phone or remotely, like through the various apps that we've got now, the software that we're able to access, to talk the employee through the proposed what you're proposing by way of furlough. But rather than making a decision, don't make the decision before you've had the conversation, because that conversation could actually change the outcome. You may listen to what somebody's got to say and change your mind, just because it can inform what you're doing and give you, I think, more protection than just sending a blanket email around to your staff. So just be careful. It's even more important that you have that conversation where you don't have a contractual right to lay off, because the individual has not envisaged this happening to them by signing that contract. And so you need to sort of put in place a mini consultation process. It doesn't have to be, as I say, like redundancy, but just talking to them, explaining what's going on, explaining the implications of it. I think the other thing to remember is that this is a job retention scheme. This is not something that they should look at as a means, from the employer to get rid of them ultimately. That's not what the scheme is about. That might happen, we just don't know. It's to sort of manage a crisis situation, to give the employees some level of pay, to allow the employers to continue trading with some support from the government. So that can be the context of the conversation, but try and speak to your employees individually, on the telephone, or preferably in the way that we're doing through Zoom or something else, and just get their views before you finalise what you're going to do. And that doesn't have to take too long. So that would be my suggestions, really.
Yeah, I mean, quite apart from the legal aspects of it, that's sensible management practice, isn't it? It's just a decent way to treat people.
Communicate. Don't tell.
Absolutely, yeah. And we've got to remember that our teams are as worried as we are about all of this, and the uncertainty around all of it. So
I think the other thing to remember is that a lot of people, it's not just the uncertainty, but a lot of people are going to begin to have relatives that are self-isolating, showing symptoms themselves, and that's really frightening and got to be carefully managed. So you may know your employees, you may know their personal circumstances, you may have a good relationship, but irrespective of all of that, it's still important that you have that open communication and that you document that as well. I mean, you could record your conversations if you wanted to. I know there are some problems with downloading Zoom recordings. I've not tried that yet, but let's hope this one works successfully. But do sort of make a note of what was discussed, and then sort of move on from there, I would suggest.
Okay, that's great. That's great. So there is a period, isn't there? A minimum period to the furloughing. Can you tell us a bit about that, please?
Yeah, there's a few things that you need to know when you're furloughing staff. As you may, I mean, there's an awful lot of information flying around, but essentially, you must furlough for a minimum of 3 weeks in order to make a claim. If you don't furlough for 3 weeks, then you've broken the eligibility requirements, and therefore you might find HMRC coming back to sort of reclaim the monies that you thought that you were going to get a grant for. Also, the other key things to remember is during the period of furlough leave, and it's something that a lot of employers are struggling with, is that the employee cannot do any work for you. They cannot provide any services to you. So that could be as simple as answering an email or responding to a WhatsApp message. So I think that one example someone gave on a sort of training session or webinar or something I was doing the other day is that they hadn't done a handover. So there was employees that were needed to carry on doing the work. They'd furloughed some employees. There was no handover done, and the poor employee was having to pick up all this stuff, had no way of getting that information out. Now, this handover, there's a debate as to whether a handover is actually providing services and working for the employer. But I think that if HMRC can see the communication ongoing on a business email and handing over, they might conclude, and I don't know what their view would be, but they might conclude that handover was actually work, and the employee that had been furloughed was then no longer furloughed and had to be paid for by the employer through their own funds. So, that shows, the problem that a lot of employers, so if there is a handover that needs to be done, do it before you furlough, is the message on that one. And again, as I said before, you must inform the employee in writing of their furlough. I mean, obviously that's what the emails that Wayne has just referred to are doing. Clearly there's a need for an agreement if the individual hasn't got a layoff clause, but you also must keep those records on your files for 5 years, because again, as we've said, the government, HMRC, will audit you. And there will be investigations going forward. So it's important to keep those paper trails.
Absolutely. Now, what about holidays during the period of furlough? This comes up quite a lot, actually.
It will come up quite a lot, and unfortunately, the government has given us no guidance. So please, whatever I say now, please just remember that the government has provided no guidance. We have a lot of employment lawyers getting in a room, obviously virtually, talking about whether taking holiday during a period of furlough breaks or doesn't break that period of leave. Now, so whatever I say, and I will come on to it a little bit later in perhaps more detail, but I'll just give you some highlights at the moment. Just in terms of the generic position that we know is that employees will continue to accrue holiday during a period of furlough leave. So that just in the normal way, they're still your employees, they still have all their rights and obligations and liabilities, etc., your liabilities to them. So they will accrue holiday during a period of furlough leave. ACAS guidance has also said that where a bank holiday, to which somebody would normally be entitled to as a holiday under their contract, they should be paid 100% of salary for that bank holiday. So that we've got a couple of bank holidays coming up this weekend. We've obviously got the May bank holiday. So in the period of time that the scheme is likely to continue at the moment, to the 31st of May, we potentially could have quite a few bank holidays falling in that period of time. And if your employees would normally be paid for those holidays, then the general proposition, again, you must take advice on your own situation, because I'm talking about a generic position here. For example, where somebody just has the statutory holiday, so it's 5.6 weeks or 28 days, which includes the bank holiday. Obviously, if your situation is slightly different, then again, you need to take advice. But the basic proposition is that if they're taking bank holidays, they should be paid 100% for those holidays. And also, ACAS have also said that if employees are not able to take all of their holiday during this current holiday year, because the normal provisions are that if you don't take it, it's forfeited unless there's a contractual provision entitling carryover. And normally that carryover is quite limited and quite prescribed. But what they're currently saying is that if employees are not able to take holiday because of the restrictions, because of being on furlough leave, then they're allowed to carry it forward, subject to a maximum, we think, of statutory annual leave of 5.6 weeks that I've just mentioned. So that's the general position that I'm reasonably confident about. And I'll come on, I think there's a specific question that we're going to address anyway about holiday.
Yes, there is,
later. So I'll pick up some of the slightly less clear position and the views on that as we come to that question.
Okay, so I think it's become a little bit clearer now, recently about the government portal, the HMRC
Yes,
portal.
yes,
Do
it
you want
has.
to say a bit about that?
Yeah, I mean, I think Wayne and I are both received the information from separate sources, which is always helpful to know. But the information that we received is that the government's portal should now be open on the 20th of April. I think there was a suggestion that it would be the end of the month, so they seem to be working incredibly hard to get that portal open. Apparently also guidance is going to be issued next week, we think, so that that will give you as employers some help in terms of how to actually make those claims through that portal. So that is useful. And as I've said, the scheme kind of currently runs to the 31st of May. So although that may be extended, we just have to wait and see what happens. So there is time still to consider furloughing if that is something that your business needs to consider.
Yeah.
Okay.
Okay. Now, we know that during the period of furlough, employees shouldn't be doing any work for the business, but I think they can take other work, can't they?
Yeah, I mean, recent guidance has said that if you have been furloughed, you can volunteer, and obviously that's something that's in dire need in terms of various positions within the industry at the moment, in particular, obviously with the NHS. But they've recently confirmed that you can take a second job. So you can still be furloughed, you can still receive whatever pay, the 80% that your employer receives from the government, that the employer pays you. That could be the 80%, or the employer could decide to top up the additional to make it onto full. But you can still receive that, and you can go out and get another job as well. So that would be normally, obviously that's a really kind of crazy situation to be in, but we are in crazy times, and I think this is just my view. Please, I need to express it like that because it's not clearly a government view, but there's a policy argument here. People are, there are various, like agriculture, NHS, care workers, they're in desperate need of people to support our most vulnerable. And therefore, they're giving us that option. Now, your employment contract may say that you're not allowed to do any work for anyone else whilst you're employed, and that's perfectly legitimate. And the usual reasons why an employer will say that is firstly to make sure that you're not exceeding your 48-hour working week. But clearly, if you're not working, then you're not going to be exceeding your 48-hour working week. And the other thing is to prevent competition, because clearly they don't want you working for them and then going to work for their competitor. So that should be the only basis, really, the competition issue that would prevent an employer giving permission. And if they unreasonably withheld that, then I think you'd have a legitimate grievance about the way you've been treated. So it is possible to go out and get another job, and that might also be something that a director, the director of a sort of sole business director might also find useful. I mean, again, I won't. I said to Wayne, I wasn't sure whether I was going to use this as an example because it might not be appropriate. But if you could bear with me on that and just say, look, an example I've seen is a gardener who provides his services through a limited company. I wouldn't have thought that many gardeners will provide their services through a limited company, but Wayne could correct me if I'm wrong. But if a gardener's doing that, if you're not providing services to your own business and through your own company, but set up on your own, does that equate to a second job? I mean, I think Wayne and I had a sort of useful discussion between professionals on this, and I think there is a big question mark over it. But that doesn't undermine the basic proposition that as an employee yourself of your limited company, you can go out and get other work to perhaps replace some of the income that you would have otherwise received had your business been continuing to trade effectively during this period of
time. In fact, I have known directors of limited companies who've done that actually already.
Okay.
Yeah.
Well, that's helpful to know. But that's I think that's a useful option. Apart from giving back to the community, which obviously is creditable in this time, it might also give you additional source of income which you might not otherwise have had. So yeah.
Absolutely, yeah. So one thing we're getting asked about a lot is furloughing of directors, whether that might be a one person company where they're the director and shareholder, or whether you're a director in your own business but you don't have any work to do because of the coronavirus, and you furlough yourself. So what people are asking is, well, what can I do for my company while I'm furloughed?
Unfortunately, it's one of those areas where we've yet to actually get any real guidance. I think there was some suggestion that the question was put to one government department and there was one answer, and to another government department and they got a completely different answer. It was like opposite ends of the spectrum. But my understanding is that you are safe to carry out your statutory obligations as a director of that company whilst you're furloughed, but no more. So it's very, very limited. I wouldn't suggest doing anything further, because I would hate for any position, but for any person in that position to then have a sort of investigation by HMRC and an audit, and then having to kind of go through the whole process of having to repay. So I think my understanding is like filing accounts, filing returns, because even though there are options to defer various things, you still have to file your VAT return. I mean, this is Wayne's area, not mine, so I perhaps shouldn't comment, but filing your VAT return still on time, and those sorts of things. So those are the sorts of things that the compliance administration, I would say, that's fundamental to your continued running as a business. Wayne, you can probably pick up from here.
Yeah, and that would be my understanding. Would be my understanding of it completely. That you can do the things like you do your books, you make sure you get your accounts done, and you file your VAT returns, but certainly do not do anything that involves providing services to customers of any sort and earns income for the business, and even things like networking. There was some debate initially about where networking fell, but I think I'm coming down on the side at the moment of no, stay away from that. We don't know categorically, but that's the sort of view that we're taking, that it seems to point to. So, okay, that's great. Right, going to move on to slightly more specific questions now, actually. So the first one of those is, all my employees have agreed to a change in contract and to be furloughed. However, I'm not sure what else to do. I'm due to complete a payroll actually tomorrow, Friday the 10th. Do I just pay my staff from my own funds, and I hope that I get that back from HMRC? What do I do about it?
Okay. Obviously, if you're not able to pay your employees tomorrow, then there would be a breach of contract, because clearly, having agreed to be furloughed, they're going to be expecting whatever that agreement, whatever agreement you've reached with them to furlough, because it could be 80% that you're hoping to get back from the government, or it could be the 100%. So if you don't pay what you've promised to pay, then clearly there's a breach. I very much doubt that in the current circumstances an employee is going to register a claim against you for doing that. There is the option, but I think it would be unlikely. So I think that your options are fairly limited, unfortunately. I mean, you could try and get a loan to tie you over. Admittedly, if we're talking about tomorrow, then we are quite close to that deadline. I think a more immediate decision will have to be made. But obviously, clearly, for anybody else in a similar position with the payroll running slightly later, then you could look at trying to get some sort of loan. I've mentioned the business interruption loan scheme. I don't know how successful that is, and I think under that scheme, I think you'd be unlikely to get any funds before you'd got the grant through from HMRC, so it might be a bit of wasted time. But I didn't know whether you had any thoughts on that, Wayne.
Yeah, I think certainly we're not seeing lots of money being provided at the moment under the business interruptions loan scheme. I think we'll see more in the coming weeks and months, but it's not a quick process at the moment. I'd certainly say if you need funding, then and it's emergency type funding, there are quicker lenders around, the likes of iWalker, Capital on Tap. You need to think very carefully about what you're entering into before you take any finance. I've got to say that. So, this isn't a recommendation of those particular bodies, but it is an acknowledgement that they're around and that sort of financing is available, albeit at high interest rates. Yeah, but certainly, there will be businesses that this is probably an early one in the stage, but there will be a lot of businesses who get to the end of this month of April and they find they have to pay their employees and they don't have enough cash in the bank, and they're relying on getting the furlough, the job retention scheme grant through before they can pay their employees, and thinking ahead about that now and how you're going to finance it is very important. Yeah.
Okay, I mean, the other option is you can ask for your employee's agreement to wait until you've got the grant. I mean, that's something that, looking forward to people who are looking to furlough, that might be something that you include in any agreement, any furlough leave agreement that you have with your employees, so that, you actually get the grant and then you pay them. That could be something that you consider. As I say, we've got anticipation that the portal will open on the 20th of April, so we haven't got too long to wait. So we just have to wait and see what happens there. And unfortunately, as you've outlined, I think the only other sort of fairly straightforward option is to pay, as you've said, from your own funds.
Yeah.
On the basis that if you're confident about the eligibility of the employees that you've furloughed and things, then hopefully you will get that 80% back from the government in due course.
Yeah. I don't think there are any particular catches with the scheme as such. As long as as long as you follow the rules and you are genuinely furloughing your employees, you should get, and you make the claim, you should get the money back at some point. So I don't think we need to worry about that at the moment. I think it's more about, actually, have I got the cash in the bank when I need to pay the employees before I receive the grant? Is a real, that's a big issue for businesses at the moment.
I think as well is that a lot of the places in the guidance, it has been talking in terms of the furlough scheme about a severe impact from the coronavirus restrictions that we're currently dealing with, but that's not consistent throughout the guidance. I think the conclusion that's been drawn is they're not going to look into it too deeply in terms of the impacts. It seems to suggest that in the guidance, and also the fact that you don't have to demonstrate when you're making a claim for this grant that that there's been a downturn, I think is quite telling in terms of the level of evidence that you have to show in order to obtain the grant under the job retention scheme. So
yeah, absolutely. Okay, so next question is, I know what information I need to send to HMRC, but with no portal, is there any way to check? I feel that I've missed something. Are employers making up their own rules on this?
Well, I hope they're not making up their own rules, because that would be slightly dangerous. There is guidance from the government about the information that you need to supply, which is obviously what I've just alluded to when I've said that they don't require you to say what impact this situation has had on your business. So there is information out there set out in the guidance as to what you need to provide, and I'll just read it out so that we know where we're coming from. So to make a claim, you'll need your PAYE reference number. Now, Wayne and I have had a debate about this offline. Wayne doesn't know what an PAYE reference number is, and he tells me that his accountant colleagues don't know what that means. So I can't enlighten you any further. I will let Wayne jump in a second, but I've seen that in terms of making a claim, there needs to be some sort of registration for PAYE online, and maybe I just let Wayne pick that up if that would be okay.
Yeah, so any business that wants to make a claim will need to register for HMRC's online PAYE services, and there will be a process that you need to go through, which involves obtaining an activation code. Now, we will be informing clients exactly how to do that, what they need to do, and helping them to do it all the way along. So this PAYE reference, it's not a term that I'd heard before, and I know a lot of accountants who hadn't heard it before, but we'll get there, we'll find what we need to find out for you to make the claim. So don't worry about that.
Okay, so just going on that was the first thing that was required. So the number of employees that are being furloughed, the claim period, the start and end date of that, the amount claimed, but you have to recognise that it's got to be for a minimum length of furlough of 3 weeks.
Yeah.
Your bank account number and sort code, your contact name, and your phone number. So that's the sort of information that you'll need. I mean, as I've mentioned already, and as Wayne has picked up on as well, guidance is due. And as and when that guidance comes out, I'm sure Wayne will be providing you with the relevant information to kind of talk you through what you need to do to make your claim, either through his assistance or by doing it yourself. So we are on it. We are keeping it up to date every day with the guidance that's coming out. So please don't worry about that too much.
Yeah. So the other thing I'd say on that, there was some guidance that came out yesterday from HMRC, just saying, adding to the list that Sarah's given there, to have your employee name and the employee's NI number as well. So that's just a bit of new guidance. I think we may have answered this next question already, but I'll ask it anyway, just in case there's anything else to say. When the furlough scheme gets off the ground, how will I find out what I need to do to make a claim and when I need to do it?
I think I jumped the gun a little bit, didn't I, really, and said, you know, there's guidance next week. You know, we've given you the dates when we think the portal's going to go open, become open.
Yeah.
Wayne will keep you up to speed with anything.
That's right.
Sorry,
I think that's what we aim to do for clients, really, is to just keep them up to speed, monitor our clients, what they're doing with furloughing their staff, and when they can make a claim. I think there is one other point there that's come to light fairly recently, in the last couple of days, is it may be possible to apply for the grant 14 days in advance of paying the employees. I think clearly if you were making a claim on the 20th of April, that we're already within 14 days, and you know we couldn't do anything now when there's not a portal ready, but it may be useful for a future month or months to know that there is an advanced period that you can make the claim on. Okay, that's great. I'll move on to the next question. For those of us that have been furloughed since the beginning of March and are part paid on a PAYE scheme, part paid by dividend, this appears to be a grey area. Do I assume that as long as I'm on a PAYE scheme as stated by the government, then I'm allowed to claim up to the maximum of £2,500?
Yeah, well, unfortunately, well, you are right in that dividends are not counted within the earnings salary pay calculation for the furlough leave that the government has introduced. So that basically means, as you said, that if you have received income through PAYE and you were on the payroll as at the 28th of February, you can claim 20%, 80%, fortunately not 20%, of your salary, or a maximum of £2,500, whichever is the lower. So it's going to be the lower of the two. You don't just automatically get the 2,500. And you can take, I mean, not that this is going to be particularly relevant, I wouldn't have thought, for somebody paid by PAYE and dividend, but you are allowed to claim for overtime and contractual commission in that calculation of salary. But again, that's probably more relevant to staff members with variable pay than it is to directors here. But.
Yeah. I know a lot of clients have not been impressed by the fact that dividend income isn't included. I'm afraid that's the way it is. The way I pay myself that way as well, and the way I tend to think about it is I've saved a lot of tax over the years by paying myself that way, rather than what I'm not getting now, I guess.
Yeah, and it's a difficult one because I think, you know, in terms of the employment lawyers' sort of commentary on this and the guidance, there doesn't seem to be any movement from government on plugging that gap to allow sort of, you know, employees employed in small businesses, almost on a, you know, as if they were self-employed type of thing, to sort of have any sort of additional contributions from government as a result of the job retention scheme. So unfortunately,
I'm not hopeful on that. Yeah, I'm not hopeful at all on that. Okay, so turning to how you work out how much you pay your employees. It's relatively straightforward if they're on a fixed monthly salary.
Yeah.
But I think this question's come from somebody whose staff are on a more variable sort of hours, etc. Do I go ahead and pay 80% of wages earned on 28th of February, even if this is more than they usually earn? February being my busiest month of the year. That's the question. So how do they go about addressing this variable pay issue?
As you say, that if somebody is paid regularly, then it's the pay that they received at the 28th of February, which I'll obviously reconfirm as well, perhaps in response to some other questions. But the government guidance does say that where an employee's pay varies, and if they've been employed for 12 months or more, then you can claim the higher of either the same month's earnings from the previous year. So you look back at April for 2019 and look at that figure, or their average monthly earnings for the 2019-20 tax year. So whichever is the higher of those, that's the basis for the 80% claim to the job retention, through the job retention scheme. So it is relatively easy to follow and relatively easy to claim for. So you just need to have a look at that, whichever is the higher, and then that's the basis for your 80% claim.
Yeah, there might be a bit of calculation to do there, going back over the last 12 months of earnings,
there would
etc.
Be, yes.
But yeah.
Hopefully you've got the relevant records and can handle that.
Should be in the payroll records. So, okay. And then the next question: over what period is the 80% calculated exactly? So I think you probably addressed that.
Fairly answered it. It might just be worth just repeating it, just because. But regular pay is what they're paid at as at 28th of February. Before tax, obviously, that's the relevant figure. If it varies, then the calculation is same month's earnings last year, or the average monthly earnings for the last tax year, whichever is the higher. If, however, they've not been employed for a full 12 months, you can claim 80% of their average monthly earnings since they started work. And if, for example, which might happen, the employee only started work for you in February, then you work out a pro rata for their earnings so far and claim for 80% of that. So just a little couple of tweaks where somebody hasn't been employed for the full 12 months, and perhaps somebody who hasn't even been employed, for the whole of February, just to help there. So that's the sort of crunch points. Those are the bits that you need to be aware of if you've got employees that are relatively recent starters.
Yeah, that's great. That's great. Slightly related point, but also with a little bit of a misconception to clarify here. I've recently taken on an employee 6 months ago has worked intermittently over the preceding 3 years. I thought I read somewhere that their entitlement as a furloughed employee was 80% of their average wage over the last 3 years. Is that correct? And if so, how is the average calculated?
Well, I think we've probably been through how the thing it should be calculated. I think the misconception here is that under the self-employed scheme that the government has introduced, it's over a period of 3 years. So that applies to people who are self-employed. Employees is as I've outlined above. So the individual who's been working intermittently over a period of 3 years that they employed 6 months ago, obviously if they were still employed as of the 28th of February, then they'd be calculated in the way that we've just outlined as a response to the previous questions that have been asked. So
okay, that's great.
That deals with the issue, or deals with the misconception anyway.
Okay, now moving on to holidays.
Ooh, okay.
We've touched on this a little bit, but I think this is a chance to go into it in a little bit more detail potentially. Are you able to place employees on holiday whilst on furlough based on the 80% supported by the government and topped up by the employer to 100% of their pay for the duration of the holiday period?
There's nothing to help us in terms of government guidance. So anything I'm about to say, please take it on the basis that this is a view being expressed, and it doesn't mean to say that it won't be a matter for litigation going down the line. So you need to take a decision for yourself as to whether you feel it's the right thing to do for your business and that you're prepared to take the risk, because we simply don't know. The issues here are, does taking holiday break the period of furlough leave? Now, I think there are employment lawyers that say one thing and employment lawyers that say the other. So when there is a dispute, you kind of have to take a particular view, because clearly there are issues that people need to be addressing. So there is no government guidance. There is nothing in the guidance, but certainly, a view that is being taken by employment lawyers is that yes, employees can take holiday during the period of furlough leave. They would have to be topped up for that period of holiday at 100%. In order to require them to take holiday, then you would have to give them notice of twice the length of the period of holiday that you want them to take. So if you have if you want your employees to take 2 weeks holiday during a period of furlough leave, then you have to give them 4 weeks notice of that. So it's like a longer game. If you want them to take 1 week, then you have to give them 2 weeks notice. If you want them to take 1 day, then 2 days potentially. But again, just this is a view that's being taken. It's not definitive. There's nothing in the government guidance that says you can do this, but it is a question that's coming up because a lot of employers are quite concerned about having what could be quite a long period of furlough leave, employees accruing holiday, and then they have the issue of how they manage that holiday situation and pay the employees for that holiday once the furlough leave is finished. Now, I've already said that ACAS guidance says that employees can carry over holiday, but if you've got a number of employees carrying over 5.6 weeks, I mean, it won't be that dramatic, but 5.6 weeks holiday into the next year, because they haven't taken any holiday till now, and then you're too busy, hopefully, for them to take holiday as soon as the furlough leave period ends, then you're going to have, 10 plus weeks, 12 and 11.2 weeks, aren't you, your statutory holiday that potentially they could be taking next year. How are you going to manage that? So a lot of employers are trying to say, well, could we ask them to take some holiday now? So subject to what I've said, they've got to be paid their full pay. So 100%, that you have to give the relevant notice. And I think that another thing that I would be quite concerned about as an employer, this is just my own personal view that I've been thinking, if an employee is self-isolating or in accordance with government guidance, because either they or their family have symptoms, then they cannot benefit from that. They should not be furloughed. They should be on statutory sick pay. Now that I know raises lots of other questions that you may have that we're perhaps not going to answer on this on this interview. But what it raises for me is, if you've got somebody on furlough who then develops symptoms, how do you pay them, and can they be taking holiday? You know, if it's during a period of furlough, and B, a period when you've actually asked them to take holiday during furlough, and then they get symptoms, what on earth is the situation there? I know it sounds a bit sort of far-fetched and perhaps a little bit ridiculous, but it could happen. In my view, you can't take holiday if you're sick, because if you are genuinely unwell, or if you are self-isolating, you know, you are on SSP, and you can't be both. So you just have to be really careful. And I think that's probably a message as well about, whilst employees cannot work, there's no reason why you cannot maintain contact with your employees to make sure they're okay. And I would suggest that is not working. That is being, adopting best practice approach to supporting your employees who are vulnerable, who are worried, and a really difficult time. Don't go in with nothing, or clearly, because, you know, in terms of, you know, their worries and everything. But just maintain a form of contact so you understand what their personal circumstances are, and you do what you can to support them.
Absolutely, I agree with that wholeheartedly. You know, there's, I guess, just because they're furloughed, the management of those and the leading of those employees as the leader of the business doesn't just go away, does it? So,
no, and that's where we have the difficulties with, can directors be furloughed? You know, in the sense of that arguably is working, because that's furthering. That could arguably be furthering your business, because that's what the job retention scheme is there for, to help you keep your employees employed, to make sure that hopefully that the economy can be picked up once this furlough leave finishes and the restrictions are lifted, and we can all get back to business as usual. But can you then furlough yourself as a director, or do you just need to leave somebody in the business being paid in the normal way, or taking a pay cut or a payment holiday or whatever, in order to actually do what you need to do for your staff? So that I leave that up to your clients, Wayne, and no doubt you and I may get some further sort of comeback from that, if anyone's listening, which I hope that they are, and I hope that they will do. But yeah, actually, so, you know, just I think, just to summarise, the holiday situation during furlough is like, watch this space. Everything that I've just said is subject to any guidance that we might get from the government, let alone updated guidance, which seems to be updated regularly, but not in relation to holiday. So just you know, and if you've got particular problems, take your own advice before you go feet first into whatever you're planning to do.
I think a really important point there about the human aspects of this. We've deliberately focused on the sort of financial and the legal aspects, but actually there's people involved here, and part of being a good leader of a business is to look after your people, isn't it? So we must not forget that at all. And
well, you're not going to have a business to come back to, are you? If your staff are feeling so vulnerable and uncertain and don't feel at all supported during this period, there's going to be some questions as to whether you're going to be able to maintain the stability of your workforce going forward. So it's worth thinking about.
I've got to say, I've got some great examples of clients out there who are doing trying their best to do the absolute right thing by their team and their employees, and it's sort of no coincidence that they're actually, you know, the most successful, profitable clients as well. It sort of goes hand in hand.
I think it does.
So going on to another sort of question on the length of the furlough, but this one is about what happens if I put my employees on furlough, then midway through the period we get a week's worth of work. Can I get them back in to do the work, pay them as normal rates, then put them back on furlough?
Again, so I mean, I'll answer the question as best I can. In terms of midway through the period, that depends on what period you're referring to. If you're saying in the middle of the 3 weeks, then you're going to be in difficulties, because you can only furlough for a minimum of 3 weeks. If they've been on furlough for a minimum of 3 weeks already, then there is no issue with you taking them back, paying them as normal for the work that they do, and re-furloughing them, as long, again, as it's for a minimum of 3 weeks. So yes, you can, subject to that minimum period.
That minimum,
you know, that's that minimum that's critical. And if you do anything to the contrary, then you're going to find that you're not eligible to make the claim for that relevant period. So you're going to end up having to pay the 80% of the employee's salary for the 2 weeks when you expected it to be reimbursed by the government, which would be quite unfortunate. So bear in mind that minimum 3 week period, and unfortunately you're going to have to manage your work around that if it's possible to delay it, or, you know, people start furlough at different times, then that might also work. So But be careful as well as about, how do you decide who you bring back to work? Because clearly, some employees would like the opportunity potentially to be paid 100% and get back into work. So be careful about how you're selecting people to be brought back, as well as who's to go on furlough leave, because again, that's another minefield. Particularly if there's maybe a bit longer than a week's work or something. Oh, clearly, if you're topping up the furlough to 100% pay, you're going to probably have some difficulty getting anybody back, because they can say, we can sit at home with 100% pay. But it's a very difficult management, staff management situation, and just be sensitive and be clear that if you're bringing people back, there's a rationale for it. It may be very clear that with the work that you've got to do, that this person can do it, but there could be 3 or 4 people that can do it. So bear that in mind when you are bringing people back in.
Yeah, great. What happens if you furlough yourself? So this is the director asking this question. What happens if you furlough yourself for 3 weeks in a 4-week month? Do you get 80% for the equivalent of 3 weeks?
Again, I'm really sorry. I'm not going to have to say that. I'm really not sure how the government would deal with that. I mean, I'm not able to advise on the sort of payroll situation, particularly when we don't even have sort of any visibility about how you're actually going to claim. But the guidance does say that grants will be prorated if you are furloughed for part of a pay period. So that's as much information as I can give you on that, I'm afraid.
Yeah, and I would sort of go along with that. I think that's as far as we can understand it at the moment, that would be my expectation of what would happen. Right. I think there were some specific questions on company directors. I think I'll go through them just so that we make sure we've covered everything. Can I furlough myself as a sole director employee of the company? I think we've covered that. Yes, you can, subject to only performing these statutory duties for the company, not selling, not doing any work that generates income for the company.
Exactly.
As a company director, will my full salary be used to calculate my claim, i.e. pay plus dividends? So I think we said no, unfortunately the dividends are completely excluded from this. It's only the pay that goes through payroll and would be subject to PAYE. Okay, then the next one is, as a company director, if I choose to live on my personal savings in order to keep the business as financially healthy as possible, would that negatively impact my claim? Did you want to answer that one, Sarah?
Yeah, well, I wasn't completely clear as to where the questioner was coming from, but I think the basic proposition, I think that the angle was, am I going to be not unable to furlough myself and claim the grant through the job retention scheme? And my view is no. As long as you've got, as you meet all the other eligibility requirements, you're not working for your business apart from the statutory duties. You're being paid through PAYE, and it's your PAYE earnings, and you were on the payroll as at the 28th of February, etc. It's a grant. It's not a means tested benefit, and unlike things like universal credit and things. So my view is that you do whatever you need to do to survive over this period, and the fact that you have personal savings, which means that you can tide yourself over in a way that some people might not be able to, shouldn't affect the grant that the government is offering, because again, it's just to sustain people in a time where they don't have a source of income. Your savings are slightly different from an income, in my view, and it's not a means tested benefit. It's a grant. It's not a loan, and that's something I think that some people are quite confused about. This job retention scheme, it's a grant under it. You're not loan. You won't have to pay it back, except if you've fallen foul of the eligibility requirements for that grant.
Absolutely, yeah. I think that's a good point. Actually, I've had some of that confusion. It is a grant, not a loan. Therefore, not repayable, and if you meet the if you stick by the guidelines, let's say. Okay, one company director is currently working. Should that cease over time, what is the minimum period allowed to claim for the furlough scheme? So we said 3 weeks, but also the current scheme runs from the 1st of March to the 31st of May. So 3 weeks minimum furlough period, but bear in mind that the current scheme as it sits at the moment ends on the 31st of May, unless the government should extend it. I think this is the final question. As I operate via a personal service company, so basically a one-person limited company, paying myself a minimum wage through PAYE and taking the majority of my earnings as dividends, I assume I am only entitled to claim for 80% of my PAYE earnings if I furlough myself and have no other options available to me. So shall I
Yeah.
take that one?
Yeah, you
Yeah.
can take that one, Wayne. Please
Yep,
do.
yep. So yes, I think as we said, it is just the PAYE income that's within scope for this. It is in certain circumstances, individuals may be able to access universal credits. Now that's a bit of a minefield area, and that is a means tested benefit as well in the case that the savings will be taken into account in assessing whether you're eligible for it. But if you are hitting a period of real hardship, I think the savings threshold is £16,000.
Yeah, that's
But
my
if
understanding.
you've got more than that, then you're not eligible. And if you've got less, you are. I would recommend if you have real hardship and you think you may be eligible for universal credits, then go on to gov.uk and search on the universal credits, and there's a lot of information there, and you need to contact HMRC and speak to them about whether you can claim or not.
But it can be claimed in conjunction with this grant under the job retention scheme as well. So it doesn't, you're not sort of barred if you're making a claim under the job retention scheme because you furloughed. You're not barred from. You can do the two things. You can you can apply for universal credit as well. So don't
Yeah.
let that stop you. Don't let that stop you from making a claim if you need to.
Okay. Great. Well, Sarah, that's the end of the question list. Thank you to all the clients who submitted their questions. That was really great. I mean, this is the first time I've done an interview, anything like this, and I've got to say I really enjoyed it.
Yeah,
I
cool.
think the dogs didn't come running in or barking. I think my son may have been in and out of his little den at the back there, just getting himself some food before he starts the next computer game. So one or two of you may have spotted that. Really enjoyable experience. So, Sarah, if people listening to this do want some specific advice, how could they contact you?
Yeah, well, obviously Wayne has my details, so that's clear. I work under a firm name, which is Brazier's Law, which is not easy because when I say it to people, they inevitably get it wrong. But if I spell Brazier's Law, it might help, which is BRASIERS Law. That was actually my grandfather's name, so that's why I've used it, because my name is Bunker and I didn't really like that as a firm name. So there we go, and Wayne will know all about that. But I'm at sarah@brazierslaw.co.uk. If you have any quick questions, or if you need some additional support on what you're proposing to do or how you're proposing to do it, clearly, obviously, I'll make sure Wayne is copied into everything, or if you can copy Wayne into anything that you send me, just because we can keep each other then in the loop and keep everything right and proper. Just so if I think Wayne's got my mobile number. If you want to call me on the mobile, I'll give. Should I give it now? I will do anyway. It's 07919 081 506. But again, Wayne's got all the information. So any help that you need, I'm sure he may be able to help, or I can help. So
Yeah,
just let us know, because there were
certainly.
quite a few things clearly outside the sort of furlough scheme itself, or just in terms of managing your staff going forward, that you might need some support with. So please let us know, and we'll do what we can to help you.
Yeah. I mean, I think we shouldn't lose sight in all of this that we at some point we will need to return to work, and I tend to think that if we're thinking this is difficult now, I think it may be even more difficult when we do that, and redundancy may well rear its nasty head. And as always in that situation, good employment law advice is essential. So just bear that in mind as well. Okay, so before I close, a few caveats. Look, we're working under a situation that is dynamic. Not all the rules are clarified, and clarification will follow later. So what we've said today is our best understanding of the rules and the guidance as at today, which for the benefit of doubt is 9th of April 2020. Please, when you're doing all of this, assume that HMRC will be auditing claims, because they will, and they have up to 5 years to do it. And I'm sure they will go after businesses who've made, let's say, fraudulent claims, for want of a better term. Sorry. And please do take advice if you're not sure. Now, as Sarah said, she's available, and we are making ourselves available to clients right through this. We are here to help you. If you're unsure on anything, please ask. We will be supporting you as much as you need in making the claims. That could be anything from just discussing it with you and you doing it yourself, to us actually submitting the claim on your behalf potentially. So we're here for that right through this period, and please use our advice and our support. Okay, so thank you again, Sarah. That was absolutely fantastic, really
Thank you.
detailed and thorough, and great
No problem.
practical advice. So I really
No
appreciate
worries.
your time and input to this. So
No worries. And I just wish everybody a safe, peaceful, happy, sunny Easter bank holiday weekend. And say, you know where Wayne and I are if you need to get hold of us.
yeah, I'm certainly looking forward to the weekend, because I gave up chocolate, sweets, cakes and biscuit for Lent, and so I'm going to be sitting on the
You're
sofa
going for
eating
it.
lots of chocolate on Sunday.
I will enjoy
Okay,
that, Wayne.
I will do.
Okay,
All
thank
right.
you.
Thank you,
Thanks.
everybody, and goodbye.